Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Getting a felony expunged in California can be a life-changing step toward better housing and job opportunities, and you may be able to do it yourself without paying for a lawyer. This process is technically a dismissal under Penal Code 1203.4, which means the court reopens your case, dismisses the charges, and you are released from many of the penalties associated with the conviction. The first and most important step is to determine your eligibility. This specific process is generally for people who were granted and successfully completed probation. If you were sentenced to and served time in a California state prison, you are likely not eligible for this type of expungement and will need to look into other options like a certificate of rehabilitation. Assuming you were granted probation, you must have completed all its terms, including paying all fines, fees, and restitution. Now, let's talk about the free part. Courts charge a filing fee, which can be over $100, but you can ask the court to waive these fees if you have a low income. To do this, you will need to fill out and file Form FW001, the request to waive court fees. You will likely qualify if you receive public benefits, if your income is below a certain level, or if the court finds you cannot afford both the fee and your family's basic needs. The next step is getting the right legal forms. You can find them on the official California Court's website. The main form you will need is CR-180, the petition for dismissal. You will also need Form CR-181, which is the order for dismissal that the judge will sign if your petition is granted. Here's a critical tip: if your felony was a wobbler, meaning it could have been charged as either a felony or a misdemeanor, you should first ask the court to reduce the felony to a misdemeanor under Penal Code 17b. You can do this using Form CR-185. Reducing the felony first can have significant benefits, especially for things like gun rights, though you should consult specific laws on that topic. Once you've filled out your forms completely and accurately, you'll make copies and file the originals with the court clerk in the same county where you were convicted. You must also serve a copy of your petition on the district attorney's office and the probation department, which usually just means giving them a copy. The court clerk can explain the exact procedure. After you file, the district attorney has the chance to object. If they don't, the judge may grant your petition without a hearing. If they do object, the court will schedule a hearing where you can explain to the judge why you deserve to have your conviction dismissed. Be prepared to talk about your accomplishments since the conviction. It's important to understand that even after a dismissal, the conviction must still be disclosed in a few situations, like when applying for a state license or running for public office, and it can still be used to increase your sentence if you are convicted of another crime in the future. But for most private employers, you can legally answer no if asked if you've ever been convicted of a crime. This process takes patience, but taking it one step at a time can put you on a path to a fresh start. Thank you so much for watching. If this video was helpful, please give it a thumbs up and consider subscribing to the channel for more guides on navigating the legal system.